Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come to court today because you have a case in this court. The case that you have in this court is classified as a criminal case. Our criminal cases are divided into two categories. You have the felonies and the misdemeanors. Now, the felony cases are our most serious type offenses, and the misdemeanor cases are referred to as your more what we call petty offense. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment that a person can get if they are convicted of the offense. The case that you have in this court is classified as a misdemeanor. If you had a felony case, the felony cases, there are 5 categories. And we'll start at the top. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. If you're convicted of a state jail felony, the range of punishment is a minimum of 6 months to a maximum of 2 years in the state jail and a fine that does not exceed $10,000. If you're convicted of a third-degree felony, the range of punishment is a minimum 2 years to a maximum of 10 years in the state penitentiary and a fine that does not exceed $10,000. If you're convicted of a second-degree felony, the range of punishment is a minimum 2 years to a maximum of 20 years in the state penitentiary and a fine that does not exceed $10,000. Or if you're convicted of a first-degree felony, the range of punishment is a minimum 5 years to a maximum of 99 years to life and a fine that does not exceed $10,000. Now, if you're convicted of a capital murder, which is the highest offense, the range of punishment is life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, the case that you have in this court is classified as a misdemeanor. And so you don't have to worry about the felony punishment range. Misdemeanors are divided into 3 categories, and we're going to start at the top and go down. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Now, the Class C misdemeanor, that's the offense that is normally handled in the JP court, which is a justice court, or the city court, which is a municipal court. And those cases come to this court when a person is convicted in either the JP court or the municipal court, and then they file an appeal, and then the case come up to this court, County Court at Law. Now, if you were convicted of a Class C misdemeanor, the range of punishment is by fine only. We cannot give you any jail time. It's by fine only. However, if you can't pay the fine, the court can convert the fine to community service. Now, if you fail to pay your fine or fail to perform your community service, then the court can issue what is called a capias pro fine. That's a warrant for your arrest for you to either pay the fine or sit out the time. Now, the next misdemeanor is a Class B misdemeanor. If you're convicted of a Class B misdemeanor, the range of punishment is 0 days to a maximum of 180 days in the county jail, a fine from $0 to $2,000, or you could be given both such fine and confinement. If you're convicted of a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days, which is 1 year in the county jail, a fine from $0 to $4,000, or you could be given both such confinement and fine. Now, as a defendant in a criminal case, you have rights. One of the rights that you have is the right to have an attorney. That's the document. You have a clipboard, and that first document is titled Judge's Explanation of Rights to Defendant Without an Attorney. And on that document, it tells you what your options are regarding your right to have an attorney. As a defendant in a criminal case, you have three options. Number one, you may hire an attorney. Number two, if you cannot afford to hire an attorney, then you can request that an attorney be appointed to represent you. Or number three, you can waive your right to have an attorney to represent you. And what that means is you can give up your right to have an attorney and you can represent yourself. Now, that document further states that if you want an attorney to represent you and you have enough money to hire an attorney, the case will be reset. Reset means you'll be given another court date to give you time to hire your attorney. Now, if you want an attorney and you do not have the money to hire one, you would need to fill out a financial questionnaire. The financial questionnaire on the clipboard is titled Jefferson County Affidavit of Indigence. You would have to fill out that document so that the proper person can determine whether or not to appoint an attorney to represent you. Now, if you desire to represent yourself, you can waive your right to have an attorney or give up your right to have an attorney and represent yourself. Now, you cannot speak to the prosecutor. The prosecutor is the attorney that works for the district attorney's office or the DA's office. That's the assistant DA in this case. You cannot speak to the prosecutor unless you first sign a waiver of your right to be represented by an attorney. The waiver is the second page that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. And I'm going to go over that document with you in about 2 minutes. The next statement is, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status, and employment. Now, if you choose to proceed without an attorney, that is, if you decide to waive your right to an attorney to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, that first document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire your own attorney, then you will place your initials on the first line to the left. If you have already hired an attorney to represent you in your case, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is to apply for a court-appointed attorney, then you will place your initials on the third line to the left. If you have already been appointed a court-appointed attorney to represent you in your case, then you will place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive your right to an attorney or give up your right to an attorney and represent yourself, then you will place your initials on the fifth line to the left and the name of the attorney. Well, you will place your initials on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will date it today's date, September 5th, 2023. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and desiring to represent yourself, then you would have to read and sign the second page that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And that document reads as follows. It states, I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily, meaning that I'm doing it of my own free will, and intelligently. Intelligent means I know what I'm doing. So it says that my waiver is voluntarily and intelligently made. Furthermore, I have been advised this 5th day of September of 2023 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. If that is your choice, then you will sign your name on the line that is titled defendant, and you will place today's date, September 5th, 2023, on the line that is titled date. Now, as a defendant in a criminal case, you have other rights. One other right that you have is a right to have a trial by jury. That area over there, where those 12 chairs are, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your jury, to sit as jurors in your case. They will listen to the evidence, they will listen to the arguments, they will deliberate, and they will decide whether to find you not guilty or to find you guilty of your charge. You also have a right to waive or give up your right to have a trial by jury. And if you do so, your case will come before the judge or the court in one of 3 ways. One way it will come before the judge is by way of what we call a bench trial. What a bench trial is, it's a trial before the judge only, without a jury. You have that right as well. The judge will listen to the evidence, the arguments, and the judge will decide whether or not to find you not guilty or guilty. Well, the other way, the second way that your case will come before the judge is by way of an agreed plea bargain agreement. What that is, a plea bargain agreement is an agreement that you have worked out with the state of Texas to settle your case. So if you worked out an agreed plea bargain agreement, it comes before the judge, and the judge can either accept or reject the plea bargain agreement. If the judge accepts the plea bargain agreement, and if you decide within 30 days that you would like to appeal your case to a higher court, you have to get permission from the judge to appeal your case. And if the judge gives you permission, your case will be appealed to the 9th Court of Appeals, which is right above us on the 3rd floor. And they will review your case to see whether or not you've been wrongfully convicted or whether or not an error has been committed in your case. And if they find that an error, or if they can either grant or deny your appeal. Now, if they grant your appeal, then they can simply find you not guilty, or they can send the case back down to this court and order this court to give you a whole new trial. Or if they deny your appeal, then you can appeal it to a higher court than the 9th Court of Appeal. You can appeal it to the highest criminal court in the state of Texas. And that court is the Texas Court of Criminal Appeals, located in Austin, Texas. You will have to file what is called a pro se petition for discretionary review. And I'll explain that to you. Pro se means that you'll be filing this petition on your own without the assistance of an attorney. And you'll be asking the Texas Court of Criminal Appeals to review your case to see whether or not your appeal should have been granted or whether or not this court has committed an error or whether or not you have been wrongfully convicted. They could either grant or deny your pro se petition. If they grant your pro se petition, they could just simply find you not guilty. Or they could send the case back down to the Ninth Court of Appeals, or they could send it down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, the third way that your case will come before the court, besides a bench trial and agreed plea bargain, the third way is by way of an unagreed plea bargain agreement. And what that means is you and your attorney and the state have not been able to reach an agreement to settle your case. And so therefore, you want the judge to decide what the punishment will be in your case. We call that an unagreed plea bargain agreement. Now, another right that you have is the right to have witnesses to come to court. Witnesses, what they do, they can either testify for you or against you. You have a right to ask them questions. If you're represented by an attorney, the attorney would ask them questions. If you're representing yourself, you will ask them questions. We call that either direct examination or cross-examination. You also have a Fifth Amendment right against self-incrimination. And what that basically means is you have a right not to testify in your case. We call that the Fifth Amendment right against self-incrimination. So if you exercise your Fifth Amendment right against self-incrimination, then the state of Texas, the government, the DA's office cannot force you to testify in your case. Now, if you waive or give up your Fifth Amendment right against self-incrimination, that just simply means that you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you, or have access to the evidence that the state has against you. If you have an attorney, your attorney will have access. If you're pro se, meaning you're representing yourself, you will have access to the evidence that the state has against you. And when I'm talking about the evidence, I'm talking about documents such as police reports, witness statements, your statement, lab reports. It could be instruments. It can be audio recordings, video recordings, whatever evidence the state has that they will be using against you, you have a right to have access to it. Now, as a defendant here in a criminal case, everyone that's here for arraignment, you have been arrested and you were placed in the county jail, and every day that you served in the county jail, you're entitled to get credit for it towards your sentence. So, for example, if you and the state has reached an agreement to settle your case for 5 days in jail, and you've already spent 5 days in jail, that simply means that you won't have to spend any more time in jail. Why? Because the 5 days that you spent in jail, you'll be given you'll be given credit for the time that you've already served in jail. Therefore, you will not have to spend any more time in jail on your case. Now, if the state is offering 7 days in jail, and you spend 5 days in jail, that simply means you will only have to do 2 days in jail because you will already be given credit for the 5 days in jail. Every day that you spent in jail can also be used as credit towards your fine and court costs. You will receive $100 credit that will go towards your fine and court costs. So if you spent 5 days in jail, that's $500 that will go towards your fine and court costs. So if the state is offering fine and court costs of $500, you already spent 5 days in jail. You don't have to pay any more money. Why? Because your 5 days in jail is $500 that will be credited toward your fine and court costs. So your fine and court costs will be taxed and retired. That simply means you won't have to pay it. Now, if they're offering $700 fine and court costs, and you spent 5 days in jail, which is 500, we're just going to subtract 500 from the 700, and that means you will only have to pay $200 in your fine and court costs. And if you can't pay it, then the court can convert your fine and court costs to community service. And every hour of community service that you perform at a nonprofit organization, $12.50 will go toward your community, your fine and court costs. So if you owe $200 in fine and court costs, that just simply means you would have to work 16 hours. You get every 8 hours is $100 that you're getting. Okay. Now, Jefferson County has a program for first-time offenders. That is for people who haven't been in trouble before. The program is called pretrial diversion. With the pretrial diversion program, the DA's office will dismiss your case. And if you successfully complete the pretrial diversion program, you can get the case expunged from your record. Expunged means erased, deleted, or wiped off from your criminal record. Now, in order for you to qualify, it has to be your first offense. You have to have an attorney to assist you to get in the program. And then the third thing, it cannot be an offense for unlawfully carrying a weapon or resisting arrest. If you are a veteran of any one of the branches of the United States military, Jefferson County has a program that is called Veterans Court. With the Veterans Court program, you will get into the program. Once you get into the program and complete the program, the case is dismissed, and you can get what is called a non-disclosure. And what a non-disclosure is, it just simply means that we cannot disclose that fact that you were in the program or had this case to the general public. Now, in order to qualify for the Veterans Court, again, you have to be a veteran of any one of the branches of the United States military. This court has a program that is called the CSI program. CSI stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking office in March of 2017. It was when the program was started. So in the past 6 years, this program, we've had partnerships with local agencies. One of the agencies that we've had a partnership with is Spindletop. Normally, Spindletop is usually here on Tuesdays. It's not here today, but they're usually here for arrangements. But anyway, with the Spindletop program, what they will do, they can do a private interview, they can do an assessment, they can develop a treatment plan, either for an outpatient or inpatient, to address whatever mental health needs that you have. You don't have to be incompetent or insane to participate in the program. Spindletop also has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. It is a drug and alcohol recovery program. We also have a partnership with our local drug and alcohol council. They have a program that is called OZAR. OZAR stands for Outreach, Screening, and Referral. Both of those programs are similar. What they will do is do a screening, an assessment, and develop a treatment plan, and you can be referred for either outpatient or inpatient treatment. If you're unemployed, or if you're employed and looking for a better job, well, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University, and Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in one of those areas that you choose, then they will assist you at getting a job in the area that you are trained in. If you have not graduated from high school and you would like to get a GED, well, CICE also has a GED program that you can enroll in and obtain your graduate equivalency diploma. Now, all of these programs that I've just mentioned to you are free. It does not cost you anything but time. And I like to say in this court, we don't just give time, we take our time. And that is, we do not just arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people, we can make Jefferson County a safer place for us to live. I like to also say that in this court, we don't have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that come before this court. And by making a difference in their lives, we're also making a difference in their home, in their family life. And by making a difference in their families, we're also making a difference in the community, because those individuals who comes out of the home goes into the community. And so in essence, if we make a difference in the individual, the family, and the community, we make Jefferson County a safer place because we produce productive people. Now, if you're interested in any one of these programs that I just mentioned to us, just let us know. We have brochures that we can give to you so that you can contact the organizations and the people that you need to talk to. Now, earlier, our court personnel passed out some paperwork, and we just want to make sure that everybody filled out that paperwork. And if you need any assistance with filling out the paperwork, just please let us know. You can raise your hand. We have our court personnel here who will be happy to assist you in finalizing or filling out the paperwork. Now, the other thing, once we get all of the paperwork from everyone, we're going to go through it and we're going to call you up before the bench one at a time. And if there's anybody here who needs to use the restroom while we're doing that, we have two restrooms right outside in the hall. We have the men's restroom, which is right by in front of County Court at Law Number 3, which is next door to this court. And across the hall from County Court at Law Number 3 is the 172nd District Court. And that's where you will find the women's restroom. So at this time, we're going to be in recess while we go through the paperwork. And then once we finish going through the paperwork, we will call you up to the bench one at a time. So at this time, the court will be in recess